So hello, welcome to our periodic webinars at Syracuse University College of Law. I'm really happy to introduce Jonas Anderson from Washington College of Law at American University and Paul Gugliuzza from Temple University College of Law. And they're here to talk about their fascinating paper, Federal Judge Seeks Patent Cases, forthcoming in the Duke Law Journal. Starts off with a very interesting fictional Craigslist ad that they'll explain to us. And so welcome, Jonas, welcome, Paul, and look forward to having a lively discussion.
Thank you.
Yeah, thank you, Shu. Let me just get my slides pulled up here for us. Okay. Great. All right, excellent. Well, thanks again, Shuba, for hosting us here. We are very excited to talk a little bit about our paper, which, as Shuba mentioned, is titled "Federal Judge Seeks Patent Cases." And as Shuba mentioned, I sort of often like to sort of start the presentation with the way that we start the paper, which is by sort of asking you to cast yourself back to like your darkest depths of pandemic-inspired doom scrolling, and imagine that you end up on Craigslist. And you see this classified ad, and it says, "Federal judge seeks patent cases. Waco, former patent litigator, recently appointed to the U.S. District Court for the Western District of Texas, longs for the intellectual challenge of a good patent fight. Can promise special procedural rules, efficient discovery, and speedy trials. Dismissal, stay, or transfer of case extremely unlikely. File in Waco and get the patent court you've always dreamed of." Okay, so this is not a real Craigslist ad, but somewhat surprisingly, it accurately describes what is happening in Waco, Texas right now. So as recently as 2016, 2017, the Waco division of the U.S. District Court for the Western District of Texas was receiving one patent case per year. As this figure, I think, dramatically shows, that has changed a lot over the past couple of years. In 2020, the Waco division received 793 patent cases, more than any other district court in the United States. So that raises the question, who is behind this caseload increase? Who is behind the fictional Craigslist ad? It's this man, Judge Alan Albright. He was appointed to the Western District of Texas in late 2018. And ever since he joined the bench, he's been aggressively advertising his Waco courtroom as the place to file your patent infringement lawsuit. So if you follow the patent law news, you've probably seen some writing about Judge Albright. He's been speaking to reporters about his enthusiasm for patent cases, at patent bar conferences about patent cases, at law firm webinars. He's even dropped in to conferences of patent law professors to talk about his enthusiasm for and his experience in presiding over patent cases in Waco.
You know, one thing I was wondering, sorry to interrupt, is this how you got onto this topic? Did he get hoisted on his own petard? Because you were wondering why.
By coming to the patent professor conference. No, you know what actually caught our eye is these stories that we saw where he's sort of explicitly advertising for patent cases. So the next slide I have up is, in fact, it's a story from the local Waco newspaper, right? Like we all know, the sort of local media has been kind of decimated over the past couple of decades. But even the Waco Tribune Herald found time to send a reporter down to Judge Albright's courtroom and wrote a story about him. And this is a quote from the story: "Traveling the country, drumming up business for his courtroom." And so, you know, this the behavior is kind of so unusual. It caught our eye. It aligns with a lot of Jonas's prior scholarship on courts seeking out particular types of cases, and some of my scholarship as well on sort of judicial incentives in terms of, you know, shaping their own dockets. And so this was like, it really just sort of caught our eye. It's like, wow, this is really extraordinary behavior on the part of this judge.
Yeah, so I mean, we were working on this last summer, not knowing we were both working on this piece. And Paul emailed me and said, hey, I'm thinking about writing this piece on Waco. And I said, hey, I'm thinking about writing a piece on Waco as well. And it really is, this is I mean, both of our scholarship coming at it from different directions. This is exactly what our scholarship is pointing towards. And it's fascinating because it's grown up so fast. I mean, that slide Paul showed 2 slides ago really shows how fast Western District has grown, and Waco in particular has grown. Eastern District of Texas took a decade to really become the predominant patent court. Western District of Texas spent 2 years at the max.
Yeah. Yeah, and in fact, we have some slides on it. The other just two points to sort of follow on that, which is sort of where the slides are headed. One, in terms of the extraordinary things that he's done to advertise to these cases, I think this is at least my favorite example, or the most eye-catching example. Shortly after he was appointed to the bench, he gave this presentation at the annual meeting of the American Intellectual Property Law Association, and the title of the presentation was "Why You Should File Your Next Patent Case Across the Street from the Hey Sugar." And the Hey Sugar is a candy store that's located across the street from his Waco courthouse, right? So it's just like, there's no reservation, no subtlety here, right? It is explicitly advertising for these types of cases. And as Jonas says, it's worked, right? And it's worked in like dramatically quick fashion. So this is just a slightly different empirical way of measuring it. This looks at patent cases filed across the entire Western District of Texas. The vast majority of these cases are being filed in Waco, and you can see that it's gone up from less than 100 and significantly less than that as recently as 2018 to over 800 in 2020. So from like 2% or less of all patent cases nationwide to over 20% of all patent cases nationwide. And in the Eastern District of Texas, which is on this slide, doesn't go back, it only goes back to 2012. But the Eastern District sort of was gaining a reputation for being a patent court in the very early 2000s, right? And really didn't start cracking the 20, 30, 40% mark until the mid 2010s, shortly before the TC Heartland decision came down and made it harder to file in the Eastern District of Texas. So the speed with which the Western District has taken over US patent litigation is really interesting.
Any sense of the appointment process for Judge Albright? I mean, it's a Trump appointee, right? None of this was, you couldn't glean these from the tea leaves of his appointment, could you? Or
well, I mean, I've read through his confirmation hearings. Nothing really in there that makes it seem that this is he would do this. He was obviously a patent litigator in practice. He's always that's his practice, and so that's what he's done.
Okay.
But I don't see any signs of this advertisement. He claims he always knew that the Waco division for the Western District of Texas would be a great place to attract cases to.
yeah,
But it's hard to say that it was obvious beforehand, either that Trump knew about it or that anybody knew about this before he was confirmed to the bench. Paul?
and as a litigator, was he an Eastern District sort of person as well, or was he?
Yeah, for the most part.
Pretty much, yeah.
I mean, that's where the cases were going.
Yeah. Anyway, yeah.
He was based in Austin, and there were a lot of firms based in Austin that did most of their work in East Texas. But he did some in Western Texas as well. He is also a magistrate judge in the Austin division before going onto the bench.
Yeah. And mentioning the Eastern District of Texas, one other thing that's worth mentioning while I have these couple of slides up is, there's a question of sort of, all right, we've seen this great increase in cases in the Western District of Texas. Where are these cases coming from? I mean, I think there's a pretty strong argument that most of these cases are cases that would have previously been filed in the Eastern District of Texas. So you can see after the 2017 decision in TC Heartland, there's sort of been a steady decline in cases in the Eastern District from over 40% of nationwide patent cases in 2015 to less than 10% of nationwide patent cases in 2019 and 2020. And the types of cases that are being filed in the Western District look a lot like the cases that used to be filed in the Eastern District. About 85% of the cases in the Western District are being filed by NPEs. And so there's also, a decent sort of observation to be made, that Judge Albright came to the bench at just the right time, right? He came in in 2018, right when patentees were looking for, a friendly forum to file in, when they couldn't file in the Eastern District as easily as they previously could. And Judge Albright came along at just the right time to sort of create that opportunity for patentees.
And so how does TC Heartland fit into all of this? I mean, why does the Western District survive and Eastern District sort of becomes more difficult?
Well, the easy answer is venue becomes tougher in the Eastern District of Texas. It's harder to establish that you have an established place of business in East Texas in Marshall, Lubbock, or Marshall, Beaumont, these small rural towns. It's pretty easy for Apple to pull stores out of the Eastern District of Texas, which they did beforehand. Right? They just wanted to be clear the Eastern District of Texas not have the threat of venue in the Eastern District. Whereas in the Western District, you have Austin, San Antonio, El Paso, big cities. And so to pull out all the Apple stores in those cities would be hurtful to Apple to do that. And it's much more difficult to do. And so that's why Waco is the perfect place to catch all this spillover from Eastern Texas after TC Heartland.
And I know in the Northern District of Texas, there were issues about the suburbs. And I mean, I know the Apple stores were pulling out of like some of the suburbs of Dallas, but okay, it's interesting.
Yes, so they did that.
It's a Goldilocks moment. It's just the right size city for.
Right, and Paul will talk about why West Texas and why not North Texas.
Yeah.
But the reason it's not East Texas is TC Heartland.
Yeah. Okay.
Cool. Just a couple other empirical slides I have, just give a sort of sense of how large Judge Albright's patent caseload is. Here's a chart of cases filed in 2020 by patent cases filed in 2020 by district court. And you can see the Western District of Texas gets about 22% of all cases filed nationwide. It's ahead of the District of Delaware, the District of Delaware being a popular patent forum because it's a popular state of incorporation, which means that under the other prong of the venue statute, right, where the defendant resides, most large corporations reside in Delaware. So venue is easy to establish in the District of Delaware under that prong, which explains why Delaware comes in number 2 in the overall number of cases filed in 2020. And then you can see below that the Eastern District of Texas as well as other relatively popular patent districts like the Central District of California, the Northern District of California, and the District of New Jersey. Just a slightly different way of visualizing this. This is by judge rather than district court. So you can see Judge Albright got about 17% of all patent cases filed nationwide in 2020. That's about 3 times as many as any other judge. Judge Noriega and Judge Gilstrap both getting about 5% of all cases nationwide. Judge Noriega on the Northern District of California, Judge Gilstrap on the Eastern District of Texas, and then some of the Delaware judges right below them. Okay, so that's just sort of the background on caseload and Judge Albright in the Eastern District. So now we'll kind of transition into the heart of the paper, which is our analysis of, why or how the Western District has so successfully competed for patent cases, and some of our arguments about why these dynamics are problematic. So we discussed like 5 main reasons in detail in the paper, but one that I've bolded here is number 1 is because it's kind of a prerequisite, right? And it's what we call judge shopping, right? Plaintiffs have to know that they will get Judge Albright, right? The whole idea of attracting patent cases doesn't work if you can't assure the plaintiffs that when they file the case, it will be assigned to you as their judge, right? And in the Western District of Texas, plaintiffs can know for sure that their case will be assigned to Judge Albright. So why is this? Well, it's because the Western District, under its general orders, assigns all cases that are filed in Waco to Judge Albright, right? So all you have to do as a plaintiff is when you're filing your case on the court's electronic case filing system, you pick the Waco option from the drop-down menu. And you know with absolute certainty that that case will be assigned to Judge Albright, right? So that certainty is very attractive as sort of a threshold matter to plaintiffs who are shopping around among different forums in which they might file their patent cases. So with that,
to answer the question of why, Shuba's question of why not North Texas, I think that's your answer. You can file in North Texas, get judges like patent cases, get judges that maybe have some similar procedural rules, but the one thing you can't get in North Texas is a guarantee you'll be assigned to one of those judges. You might get some other judge that doesn't feel the same way about patent cases. In the Western District, you can know with 100% certainty, Judge Albright will be your judge.
I think this was stated, but just to underline it, it's because he's the only judge in the division. Is that right?
Yeah.
Pretty much. Yeah.
Yep.
Yeah.
And
But
did
it's
he-
important to note, this just sort of foreshadows some of the things we talk about sort of as law reform recommendations. There's nothing in like federal law that requires judges to be assigned to particular divisions within a district, right? The divisions are created by statute, but the terms that, judges are only appointed to the district. So it's entirely within the court's power, both, how to allocate sort of judicial workload among the various divisions in the district, and how to assign cases among the various judges and the various divisions. So there's nothing like, the court, it's entirely within the court's power to change this dynamic, which, sort of facilitates judge shopping.
Yep.
Yeah, interesting. And just as further
Um,
background, did Albright have a pretty good reputation as a patent litigator, or is it just the fact that he was a patent litigator that really makes it even more attractive to get him as the judge? Or is he known as?
I think he had a good reputation as a patent litigator.
Yeah.
But I mean, to my knowledge, he's one of the few patent litigators that is a judge. That's definitely
Right.
true, and that's what he'll say is the reason people file in his courtroom.
Yeah.
Our argument is that, well, that's part of the reason.
Yeah.
There's a lot more reasons that someone would want to be in front of you, in addition to you being a patent litigator in practice.
Yeah.
Speaking of those reasons, so why else does Judge Albright's courtroom attract patent cases? The next thing on here, and one of the really important dynamics, is that he sets a very fast case schedule. So we won't go into too many of the details here. Certainly, if you read the paper, you can see more about the specific deadlines he sets. But just generally, having very quick deadlines, processing cases very quickly, or at least allowing plaintiffs to threaten a quick resolution of the case, appeals to plaintiffs who are looking to pressure defendants into a quick settlement. And importantly, I think it's been important over the last year, plaintiffs have been able to maintain the threat of a quick trial even in the midst of the pandemic, right? Judge Albright has been very vocal about, he's held two in-person jury trials since the pandemic began. He's been very vocal about sort of sticking to trial dates, even in the midst of the pandemic. One of the trials, which probably anybody who's followed patent law has heard about, just ended earlier this month. It was a suit by a company called VLSI against Intel, and it ended in a plaintiff's verdict to the tune of $2.18 billion, which I think is the second largest patent infringement verdict in history. So one of the questions we often get when we're talking about this paper is like, well, this fast schedule is great, the judge shopping is great, but isn't like the most important thing if like plaintiffs are actually winning? And and to this point, we only have 2 data points in terms of like full-blown trials, at least jury trials before Judge Albright. One ended in a defense verdict, and the other one ended in a $2.18 billion verdict for the plaintiff. So our data set is still really small in terms of outcomes after trial. But I guess on the other hand, the average size the verdict is well in excess of $1 billion. So I think it's too early to say, like, on the merits, do plaintiffs do better? What's the jury pool like in the Western District of Texas? I don't think we could say anything about that with too much confidence. But certainly this verdict is going to catch the eye of a lot of patent plaintiffs.
Right. I mean, just to dot the I that Paul just stated, if you're trying to attract plaintiffs to your district, I don't think most of them care about the average damage award. But to the extent they do, this Intel award will attract even more cases to the district. I think most plaintiffs think we're not going to go to trial. We're not going to get that far. Let's get quick settlement. And so all the other things Paul's talking about are more important. But the damage awards actually do matter. And so far, at least, they've been pretty large.
And it was a quick trial, right? I mean, I don't know the exact, how long was the trial? It was pretty quick, right? It must have been, if he's.
About a week, I think, right?
A week, so 10 days, maybe.
Yeah.
So that's quite a big payoff just in terms of the length of time it took to get it too. So
okay, just to move on to a couple other things. Oh, there I get the verdict, the fancy handwritten verdict sheet for you, just in case you want to see it.
I haven't seen it.
Yeah, there you go. There's the verdict. 1.5 billion for one patent. It was actually over two patents, right? 1.5 for one and only 675 million for the other one. So we'll see if that, and we'll also, obviously see if that stands up on appeal, right? Which the Federal Circuit has a reputation recently for slashing these sorts of damage awards pretty significantly. So that's certainly not the end of the Intel story by any means. But in any case, just to sort of hit some of the other reasons that we talked about in the paper that are bringing plaintiffs to Waco. Another big one that we think is important is the way that Judge Albright handles and rules on motions to transfer venue, particularly motions seeking sort of convenience-driven transfers under Section 1404A. So Section 1404A allows transfer just basically for convenience purposes, right? Yeah, you could file in the Western District of Texas, but there's some other more convenient forum out here, the defendant will argue. Often, if you're talking about a defendant that's, Apple or Google or someone like that, the more convenient forum they're going to be arguing for is the Northern District of California, where they're headquartered. Some empirics here. So Judge Albright, as far as we can tell, decided about 22 motions to transfer cases out of the Western District of Texas under Section 1404A. He's granted only 5 of them, which makes the grant rate about 22.7%. Just as a sort of benchmark, the nationwide grant rate in patent cases was about 50%. So Judge Albright is noticeably more reluctant to send a patent case away from his courtroom than other judges. Another interesting dynamic here that requires just a little bit of explanation is that Section 1404A, it allows transfer not just from one district to another, say the Western District of Texas to the Northern District of California, but also from one division within a district to another division within the same district. So for example, from the Waco division of the Western District of Texas to the Austin division. Interestingly, when we were working on this paper over last summer, we noticed that there had been a large number of unopposed motions to transfer cases from Waco to Austin. And this struck us as kind of strange, right? Because you have a plaintiff who's chosen to file the case in Waco, right? But then in 51 of those cases, the defendant says, hey, I would like to transfer the case you just filed in Waco to Austin. And the plaintiff says, okay, fine, right? That seems kind of strange, right? And that's what we really looked at, is like, this is like huge, very telling evidence of judge shopping, right? The plaintiffs are filing the cases in Waco solely to get the case on Judge Albright's docket. Then when the defendant wants to transfer the case from Waco to Austin, the plaintiff is fine with it, so long as, and Judge Albright does, Judge Albright keeps the case on his own docket, right? And so the only reason the plaintiffs are filing these cases is to be assured, in Waco, is to be assured that Judge Albright would be assigned to it. Where do they actually litigate it? They don't care if it's Waco or Austin, so long as Judge Albright keeps the case in front of him, and that's what he was doing. There's also been some opposed motions here. To transfer from Waco to Austin. Judge Albright's granted most of those, and again, he's kept all those on his docket. He's actually denied a few of these Waco to Austin transfer motions recently, but they're all since the pandemic began, and so right now the courthouse in Austin is closed for trial. There are no trials in Austin, but Judge Albright in Waco, as the only judge, has been continuing to conduct trials in Waco. And so since this dynamic emerged, he started to become more stingy about transferring cases from Waco to Austin. So I think putting a lot of this together is really, it's very attractive to plaintiffs, whether you want to get assigned to Judge Albright in the case of the unopposed motions we were looking at last summer, or if you want to be able to threaten a quick trial in terms of what's going on now that he's sort of being a little more skeptical of the Waco to Austin transfer requests.
Yeah, and one last point on the 1404A transfers, a lot of motions to transfer Judge Albright was just sitting on and wasn't making a decision on for a long time, and that has the effect of keeping the case going. You're litigating different items in the case, and that has the same effect as denying a motion to transfer. The Federal Circuit has recently kind of bench slapped Judge Albright for that practice, and now he has become much more timely at issuing denials in general. But this venue transfer issue is a real one, a live one at the Federal Circuit, and they're reviewing him through mandamus motions a lot of times in numbers that are way beyond what they typically do for all cases. They've reviewed him more in the last, I think, 4 months on mandamus actions than I think they have for, Paul knows the exact numbers, but for the past 5 years, they haven't done nearly as much as they've done in the last 4 or 5 months.
Yeah. I mean, basically the only time previously we've seen this amount of mandamus activity at the Federal Circuit was when the Eastern District of Texas was starting to emerge as like really the patent hotbed. So starting like around 2010, when the Federal Circuit in a case called TS Tech first granted a mandamus petition seeking a transfer of venue, that sort of spurred a slew of mandamus petitions out of the Eastern District of Texas over the next 5 years or so. And basically we're starting to see history kind of repeating itself with the Western District of Texas.
Now, typically when you have transfers between two divisions within a district, does the judge relinquish it from the docket, or is that unusual to see the 51 here?
Yeah, I think it's unusual. I wouldn't say it's like totally unprecedented, but usually, right? I mean, the reason why judges are assigned to particular divisions is they sit generally in that division. And so if you're transferring a case to a division in which they don't sit, they're not going to keep the case. And so,
I mean, Waco, as you know, Waco and Austin aren't that far from each other, at least within West Coast.
So I have a little more
west of the Mississippi standards. So,
with Northern California, and there you have Oakland and the San Jose division. Those are further away, at least driving wise. And the judges there might be really less familiar with patent law than San Jose. And so in those cases, though, any motion to transfer that is granted between the divisions, I can't imagine a judge would retain the case because he's sitting in San Jose. Going to Oakland would be unheard of. In this case, Judge Albright actually lives in Austin. So for him, he might prefer to litigate in Austin as well as the litigants. And so it's just all this points to this judge shopping idea that Paul talked about. And that's what we're really concerned about, is that not that Judge Albright shouldn't hear patent cases, but Judge Albright shouldn't hear every patent case.
And convenience of the judge is kind of irrelevant to this transfer motion.
If it's true, right, that Waco and Austin, are sort of fungible, then why are you assigning judges? Why is Judge Albright assigned solely to Waco, right? I mean, if Waco and Austin are fungible, then the judges ought to be fungible as well, right?
Right. And so what should happen here? I think you described the San Jose Oakland situation with this transfer. Would it just get randomly reassigned to a judge in the Austin division? Is that We'll just go back.
Yeah,
to
so this is up to the district. I think they would just randomly reassign it, or they might have the chief judge could have discretion about how it would be assigned based on workload, et cetera. So those kind of murky issues that you can't really get a handle on exactly how they're done. But I think in general, one thing we can say is that it's not typical to have every single case stay on the transferring judge's docket.
Yeah, I guess what I'm getting at too is that's not Judge Albright's decision to retain it, is it? Or is that's kind of an odd.
Yeah, it is. I think it is his decision.
Yeah, he
It is
certainly
his
treats
decision.
it as if it's his decision,
Okay,
right?
okay.
I mean, I think I've heard some mutterings that maybe there's some disagreement about that. But I think for now, Judge Albright believes that, as the presiding judge, it's his decision to whether to transfer the case, and if he does, to retain the case on his docket.
Interesting. Okay.
Yeah.
Yeah, fascinating.
Yeah. I just before.
Let me.
Go
Last, sorry.
Yeah. No.
I think what's important here is that litigants know this is happening, and they know that they can get the transfer and retain Judge Albright's on the docket. If he was doing it part of the time or some of the time, I think you see parties less inclined to ask for this transfer because they know they can get the transfer and retain Judge Albright 51 out of 51 times.
Right.
That makes them secure in asking for this and knowing they're going to keep Judge Albright on the docket.
Right. And I guess if the plaintiffs really are indifferent between Waco and Austin, why aren't they filing in Austin to begin with? Right. So
yeah, that's the basic point. Very, very well put. Just to highlight just a couple of the other reasons, to keep the discussion going, but also to just make sure we sort of cover all the bases here. Another thing that is attractive to plaintiffs about the Western District of Texas is the way in which Judge Albright handles stays of litigation, right? So often we see parties requesting, defendants in particular, requesting that infringement suits be stayed pending, usually inter partes review at the Patent Trial and Appeal Board. By and large, courts generally will grant stays, particularly if the PTAB has decided to institute review of the patent in suit. Judge Albright is not so, well, at least there's a lot of suggestions that Judge Albright will not be so willing to stay litigation pending PTAB review. And in part because of his very fast case schedule that he sets, it allows him to say that he will actually finish more quickly than the PTAB. And interestingly, the dynamic also works the other way. So, you may have seen, and maybe some of the people who are listening out in the webosphere have seen, there's a lot of controversy over the PTAB's practice under a couple of decisions called NHK Spring and Fintiv, which say that the PTAB has discretion to deny the institution of inter partes review, depending on how far along parallel infringement litigation is. And we've seen cases in which the PTAB has relied on Judge Albright's fast schedule, which he may not necessarily stick to, right? But it's at least out there as a schedule in denying institution of inter partes review under Fintiv. So knowing that your patent case will not be stayed pending PTAB review is also attractive to patentees. There's also kind of a normative policy aspect going on here, where Judge Albright has gone on the record a few times talking about sort of how he strongly believes this is a text order that he entered denying a motion to stay. This is the only document associated with this denial of the motion. There's no actual order, just some text on the docket. But it's interesting because one of the number one reason given for denying the stay pending an instituted inter partes review was the court's strong belief about the Seventh Amendment, right? And in particular, that the Seventh Amendment provides a plaintiff with a right to a jury trial on the question of patent validity. Historically, normatively, doctrinally, kind of a questionable claim that there's definitely a Seventh Amendment right to a trial on patent validity, but it certainly informs the way in which Judge Albright approaches motions to stay.
Yeah, and this is of the 5 points we bring up in the paper, this is maybe the strongest reason to file in West Texas, is because you have a judge that is openly, and he's out there saying this at webinars every weekday, saying that he wants to beat the PTAB. He doesn't want to go to PTAB. He wants to give people a day in court. And so if you have a patent and you're suing a bunch of people, and you can know that this one judge will protect your patent from the PTAB death squads, as they've been called. That is a huge advantage over every other judge in the country. And this slide that Paul points out is he doesn't just have the law incorrect. Congress has stated just the opposite, right? Congress has said, we established the PTAB in order to give these fast-track reviews of patents that are in litigation, right? And so he has gone out and said, I don't think this is right. I don't think what Congress has done is right, is essentially what he's saying. And so that is a battle between, I think, Judge Albright and Congress that is problematic on a number of levels. This is one of the big attractions of filing before Judge Albright.
Last one, rulings on motions to dismiss. And in particular here, we're thinking about motions to dismiss under Section 101 for lack of patent eligible subject matter. And again, this is because, just sort of generally speaking, there's an awful lot of sort of the do it on a computer type software patents that are being asserted by NPEs in the Western District of Texas. So at least initially, a lot of these complaints were being met with motions to dismiss for lack of patent eligible subject matter. Those motions have been incredibly unsuccessful. So as far as we can tell, Judge Albright has decided 12 motions to dismiss for lack of patent eligible subject matter. He's denied all 12. And you can compare that with grant rates that are noticeably higher in other leading patent courts. And in fact, it almost seems as if defendants have sort of given up filing motion to dismiss under Section 101 in his courtroom. It's been several months since I've seen a decision come down on 101 grounds. And in part, it's because in sort of his last significant decision on Section 101, George Albright went through a litany of reasons explaining why he believes that resolving Section 101 issues are rarely appropriate on a motion to dismiss, right? Now, maybe you think the Supreme Court's 101 case law is wrong, maybe you think it's right, maybe you think it's confusing, maybe you think it's not, right? But whatever you think of that case law substantively and normatively, this assertion that resolving 101 on a 12b6 motion to dismiss is not appropriate just flatly flies in the face of federal circuit case law. Even after the federal circuit in cases like Atrix and Berkheimer started to recognize that there could be factual components to the eligibility analysis, the court has continued to regularly affirm 12b6 dismissals on eligibility grounds. But Judge Albright has basically said, look, I will never definitively resolve this issue on the pleadings. And I think that's also sort of discouraged defendants from even trying to file these sorts of motions anymore.
Most of the cases, his cases go to trial. I mean, are there some? What's the statistics for summary judgment motions
on Judge Albright in Section 101?
Yeah.
So I've not seen
general,
any summary judgment motions on Section 101.
Okay. Or in general, is he pretty much going to trial?
On 101, I mean, I think
defendants lose and it goes.
Yeah, I don't think they're trying 101, right? And I mean, there's other dynamics at play here too. Like if you're getting to trial, given that 101 is often decided by the judge, but 102 and 103 are going to go to the jury. Defendants sort of transition away from the 101 to the 102 and 103 and 112 defenses at trial. So it's not all necessarily Judge Albright specific. But it's this key point, right? I mean, the motion to dismiss is really the arguable innovation, like procedural innovation of eligibility law, because it's pretty much the only ground of eligibility that can be decided on the motion to dismiss, which is the defendant's first document that it files in response to the complaint. And so if you can't get the dismissal there, then you just sort of go to the more, the more traditional bases of challenging validity.
And so looking at, I don't know if you've done this yet, I'm trying to remember, but some of his other rulings, does he give pretty quick Markman hearings? And do do you have a sense that he reads the patents pretty broadly? Or what's your sense there?
We didn't really include that in the paper. Anecdotally, he is very quick to get to Markman. That's one of his one of the scheduling things that makes his court attractive is he gets to Markman incredibly fast pace. He does read, from what I've read, he does tend to read claims fairly broadly, give them a wide berth, which exposes them to more prior art and encompasses more infringing devices. I don't have any data on how he does on appeal, et cetera, because he's such a new judge. It's really hard to get anything
Right, yeah, you don't
out there on that yet. Yeah. But I do suspect that we'll see a lot of reversals. But he's just a plain meaning judge. He wants, what's the plain meaning? We'll go with that. In a ways that maybe some other judges aren't. But I think, I mean, this is all anecdotal, again, just me reading a bunch of opinions. But I think he's pretty fair in general in his claim construction. I think he's pretty fair in general as a judge, but all these procedural innovations that Paul just walked through tilt the playing field completely for the plaintiff and make it so favorable for plaintiffs to litigate in front of him. They all want to be in his court.
And I'm getting the sense, I'm sorry.
No, I was just gonna say on the Markman question in particular, on the procedural side, one of the points that I think the Federal Circuit has objected to in some of the mandamus petitions on transfer is that, he will barrel ahead and do Markman, right, while the transfer motion is still pending. And I think that's one of the things that the Federal Circuit has taken exception to basically, look, if someone files a motion to transfer, you decide the transfer motion before you start deciding Markman issues. And so I think that it was attractive to plaintiffs, and it's one of the things that the Federal Circuit is pushing back against a little bit.
I'm looking at some of the names of the plaintiffs, not to prejudge or anything, but I'm getting a sense that, would it be safe to say that a large percentage, if not exclusively, are NPEs, or was that unfair? I mean,
yes, it's not exclusive. There's about, we estimate 10 to 20% are practicing entities that are plaintiffs, but it's a large percentage that are not.
Yeah. How much is the University of Texas involved too? I'm wondering. I'm thinking of like, like the Western District of Wisconsin. You got a lot of
I haven't seen
cases. Yeah.
Like in the appendix of our paper, we list all the large plaintiffs, and they're not one of those plaintiffs that's listed. They might have one or two cases, but there are not many that they are directly involved in as themselves.
Interesting.
Okay, just just a couple other wrap-up points here. So one thing that comes up that I think we've alluded to a lot of this so far, but maybe helpful to summarize a little bit, is sort of what's the harm here, right? And in the paper, we sort of categorize and identify it as three types of harm. One is just this idea of judicial partiality or potentially capture of the court, right? I mean, this idea, as we've discussed, to attract cases, a judge has to favor one side, and to keep them coming, it's got to continue to favor that side. There's also an efficiency cost here, right? If you're designing procedure for the main purpose of attracting cases, not to sort of balance, cost and accuracy, which we would normally think of as the normative goal of a dispute resolution system, then you're going to get rules that are sort of inefficient or potentially wasteful. And then three, there's some separation of powers concerns, right? Jonas alluded to the sort of tug of war between Judge Albright and Congress about, what's the point of the PTAB or of PTAB review. You can also view it in terms of, you have this individual judge who's sort of taken it upon himself to redesign basically the entire patent litigation system nationwide. And we might question whether that's an appropriate role for one single federal district judge, or maybe a matter best left to sort of the collective wisdom of judges, various committees like the Judicial Conference or Congress to do that sort of restructuring as well. So what can we do? So we propose a couple of solutions in the paper. One that we've alluded to in some of the discussion already. Some randomization of case assignment would be a good start, right? It would thwart the ability of plaintiffs to judge shop, and it would also sort of discourage judges or maybe dull the incentives for judges to engage in this sort of judicial advertisement. As we said, right, it's currently, like, I think most people think that cases are just usually randomly assigned. There's absolutely nothing at all in federal statutory law that requires randomization of case assignment. So the way the Western District is currently assigning cases is perfectly lawful under federal law, but we think that should change, right? And we should ensure that no judge has a greater than some percentage probability of being assigned a case. In the paper, we say like 50%, but I think the number, at least in my mind, is less important than this basic notion that parties should not be able to predict with absolute certainty who their judge should be. And then the second thing, which we also alluded to, is maybe tweaking the venue rules a little bit, right? So what allows patentees to file these cases in Waco, Texas, is because venue is determined on a division-wide basis. And because many of these large defendants have operations in Austin, which is also in the Western District of Texas, that allows the parties to file their case anywhere in the Western District, whether it be Austin or Waco, or even if they wanted to, El Paso, Midland, Odessa, or San Antonio, right? So we suggest, what if we tied venue rules a little more closely to the division in which the case is filed, not just the district as a whole? That would at least make it harder for plaintiffs to file cases in Waco against defendants whose operations are in the Western District of Texas are entirely in Austin and not in Waco. And I think that's what I got in terms of the slide presentation, but obviously we're happy to continue the discussion.
Yeah, this is really fascinating and raises a lot of great questions. I guess you alluded to the fact that maybe in some of these issues, some of these motions, and the federal circuit might come to the rescue. I guess everyone's trying to do that on the mandamus side, but
yeah, I mean, it's really hard, right? I mean, on the mandamus stuff, I mean, I think there's real questions about, like, is that really an efficient way to, granted that, even assuming that what Judge Albright's doing is problematic, is basically allowing case-by-case interlocutory appeal, like a really good way of controlling this. And I'm not so sure, at least just speaking for myself, I'm not so sure it is. And then the other point is that, given that the vast majority of these cases are filed in view of settlement, right? And in fact, the majority of the cases do settle here. There's nothing for the federal circuit to review. So I think the federal circuit is really not well situated to control this kind of conduct.
Yeah, I was thinking more of the 12b6 issues you mentioned, and maybe some of the other motions.
Not appealable, right? If a denial of a 12b6 motion just means the case is headed towards discovery and towards summary judgment, and so that's also not appealable.
Yeah, a lot of these things are not appealable. The judge shopping issue, we've talked about this a lot. We're not sure that's challengeable. The FinTab stuff, all the stuff with the PTAB, has proven not to be appealable. That's by statute. And so if the PTAB wants to say, we don't think discretionarily we are going to grant review, that's not appealable. And so if Judge Albright can influence that and can make it less likely you get PTAB review if you are in front of him, great for him. It can't be reviewed by the federal circuit. So a lot of these things are in the cracks between procedure, which is reviewable, and like some kind of administrative or procedural-ish practice that's not reviewable by the federal circuit. So I think the federal circuit can do something about Judge Albright, but they can't affect change on the whole. And that's why both of our proposals are really aimed at either the district, the Western District of Texas, or higher up, Congress or the Supreme Court. And they are really the people that have to change the rules that govern what Judge Albright can do and can't do.
Yeah, basically about judge assignment. Do you have any other examples of, or is this Waco unique in having, a division with only one judge in it? So when you're picking the division, you're picking the judge. You have a
not unique at all. About 53, I think we counted, it was 53 district courts out of 96 that have at least one division with just one judge. So, like, Western District of Wisconsin was a rocket
Right.
docket. They
Right.
had two judges, but most of the patent cases were assigned to one of the judges because of
Right.
some discretionary assignment practices, and that led Western District for a while to be the patent hotbed it was.
Right.
So there are other districts that could attract these cases if they wanted to, and that's part of the problem I think Paul and I are pointing out is that this is a story about Judge Albright, but it's really a story about the patent litigation system as a whole. We've seen this exact thing in the Eastern District. It just moved to the Western District, and I'm sure it's going to move somewhere else in the future.
Yeah. It could happen. It could, the point I think the brought up is like, this could happen anywhere, and it could happen in any type of case in which, the venue rules are sufficiently lax to allow sort of relatively broad choice of forum.
Right. Right. I mean, I guess it's just patent now. I guess that was my next question. Are we seeing this in other substantive areas? And we were sort of, 20, maybe 30 years ago, now we're seeing in securities law out in California, but now
we
I guess
saw it in bankruptcy in the late
bankruptcy,
80s, early 90s between Delaware and Southern District of New York, and that was a real competition. Like Delaware and New York were competing for those cases. Delaware won, in the same way that Western District is now competing for those cases with Delaware and Eastern Texas, and it's winning currently, but it's not going to win forever. But I mean, Paul's and our broader point is that this court competition is problematic for patent law in general, but the federal judiciary as a whole. And there are simple fixes. These are easy fixes we could make, which wouldn't stop this problem, but would really clamp down on court competition in general.
Well, I guess maybe this is to end on this point as a point of discussion. I mean, when I was reading the paper and even your presentation now, it seems like the problem here is there isn't competition. I mean, it's kind of interesting how we think about structuring the rules by which judges are. But I think I agree with your general point that we have an adversarial process in the U.S. compared to what we have in Europe, and so it is about competition. It's not about the merits at some level. But what's odd about this is that there's no. It'd be nice if there were at least two judges in this division. So admittedly, the Western District of Wisconsin may be to the contrary, but at least there's some competition among the judges of some sort, right? So any thoughts about that, or just in terms of how we think about adversarial processes in the US, procedure and substance? Or
go for it, Paul.
Yeah, I mean, I think the problem, right, if you're talking about, let's have more judges competing to get these cases to sort of create an equilibrium. I'm not sure that model works here, right? Because I think what you might end up with is a race to the bottom. Yeah, because the audience here, right, is what you're competing for is the affection or attention of patent plaintiffs, right? That's literally like the only thing you're competing for.
Right.
And so
that's
having more
between
judges competing might even be worse. Because then you've got to one up your fellow competitors. So I just think this is one of those situations where like the market idea just really does not translate into judicial case assignment.
And actually, I disagree that we haven't seen this. There's competition for these cases between Judge Albright, the Eastern District judges, the judges on the Western District of Pennsylvania, which have tried to give these cases and failed. Why? Because Judge Albright has a lot more things to offer plaintiffs than Western District was willing to give. And that's the problem. I think the Western District of Pennsylvania has good judges. They wouldn't give as much to plaintiffs, and that's good. But that means the plaintiffs are going to go elsewhere, and that's bad.
There is competition. It just looks like there's not because he's so definitively won.
Right. Yeah, it's interesting, and it sort of has this little fiefdom there in a very unique.
He's the Google of patent.
Yeah, that's exactly right. That's exactly right.
Well, thank you so much. This is great. And just, I guess, whatever final words you have, but I guess a lot of people are wondering, as far as the reform aspect of this, where are you going with the paper? I know, Federal Judicial Center, Congress.
I mean, I'll speak for myself. We've kind of talked about this in general, but we don't really publish it. I'd love the Federal Judicial Center to get interested in this notion, because this to me is something the Federal Judicial Center could do in a non-binding form. Just tell the Western District of Texas, tell all the districts in general, we'd like these formats for your division assignments. And that would, I think, alleviate a lot of this concern with single judges dominating the market. So I'd love to get in front of the Federal Judicial Center with our proposals.
And I think just to bring it full circle back to what we started at the beginning too, it's important to have us, like, this is really early days, right? I mean, this has only been going on for he's only been on the bench for barely 2 years. And so, I think slowly there's becoming awareness of some of these problems, and hopefully our paper is contributing to that awareness somewhat. But the gears of law reform take a while to turn. So I think it's important to keep in mind, like, this is early days. We're just starting to sort of like discover some of these problematic dynamics, and hopefully, as Jonas says, bodies like the FJC or maybe the Judicial Conference, which writes the federal rules of civil procedure, will be interested in these issues.
Well, thank you so much, Jonas. Thank you so much, Paul. It's a great paper. Recommend it to everybody, and congratulations.
Thank you for having us.
Thanks, Shubha.
Thank you. Thank you.